Case number E935 of 2025, the public versus Francis Washira, Alexander Roburoi, Isaac Ochieng, Michael Wabukala, Evans Kimayo, Abdulrahman Ali Sudi.
If it pleases you, Your Honor. Mr. Mbarak, together with Mr. Callisto, appear for the accused persons, Mr. Wanjiru, Mr. Abuya, and I, Kipkoech Honor, appear for the Law Society of Kenya, for IMLU, Voco Africa, as well as the family of Brian Odhiambo, who is missing. I don't know if my colleagues from the ODPP are now tiptoeing into court. They ordinarily occupy the front bench, but I think they were late this afternoon.
Your Honor, Ms. Sang, appearing alongside Mr. Wakasiaka and Mr. Smith for the ODPP. And Mr. Smith.
Yes.
Your Honor, we are ready to take the ruling.
This is the ruling of the court. They should not be released on bond. They do not deserve to be admitted to bond or bail. They should be denied bond or bail. This is the straight and loud plea to this court by Elizabeth Auma Ogega, the mother of Brian Odhiambo, who has been missing since the 18th of January 2025. Wherever he is, Brian must be proud of the kind of mother she has. In the entirety of her affidavit, the name Brian only appears once in the first paragraph, and in subsequent paragraphs, Brian is substituted and described as my son. It is sad that this is coming a day after Mother's Day. This heroine deserves to be celebrated. It is my prayer and desire that one day Brian would resurface and get to celebrate Mother Elizabeth Auma Ogega. Back to this case. This is a ruling premised on the objection by the prosecution, the family of the victim, Law Society of Kenya, and the civil society led by Voco Africa and IMLU, that the accused persons herein should not be released on bond or bail. For clarity, the accused persons jointly face a charge of abduction with intent to confine, contrary to Section 256, as read with Section 259 of the Penal Code. The particulars of the offense being that the accused persons, Francis Washira Gashoki, Alexander Lorogoi, Isaac Ochieng Odhiambo, Michael Wabukala, Evans Kimayo, and Abdulrahman Ali Sudi on the 18th of January 2025 at 10 a.m. at Bondeni area in Nakuru East Sub-County within Nakuru County, jointly with others not before court, abducted Brian Odhiambo with intent to cause him to be secretly and wrongly confined. The penal section provides as follows. Any person who kidnaps or abducts any person with intent to cause that person to be secretly and wrongly confined is guilty of a felony and is liable to imprisonment for 7 years. I will be explaining why I chose to highlight the penal consequence of this offense at its necessary stage later in the course of this ruling. All the accused persons pleaded not guilty to the said charge. The accused were represented by Mr. Callisto, the legal officer at the Kenya Wildlife Service, where the accused persons are its officers. Mr. Callisto prayed that the accused be released on bond pending trial, which application was vehemently opposed by and the consequent basis of this ruling. In opposing the application, it was filed in this court an affidavit sworn by Elizabeth Auma Ogega, the mother to the missing victim, Brian Odhiambo. In a nutshell, the affidavit advanced 5 grounds in objection to the accused's admission to bond and was set out as follows. 1. That there was reasonable apprehension that the accused would interfere with the prosecution witnesses. A case at hand is that the deponent was approached by a Mr. Osea, who attempted to offer a bribe or financial inducement in pursuit of her to drop the complaint. The investigation, that's number 2, the investigation in the matter were not complete, and there was likelihood of the accused persons interfering with the ongoing investigation if admitted to bond. It was cited that the scene of crime herein was under the jurisdiction of the Kenya Wildlife Services, where the accused persons are employed. 3, that there was clear imbalance between the family of the victim, who are ordinary civilians, and the accused persons who are state officers, who are fully armed, and intimidation in the case is not a mere perception, but a real threat. 4, the evidence against the accused is watertight, hence conviction is almost guaranteed, hence releasing the accused persons on bond would in itself be a motivation to the accused to abscond. And finally, that it is necessary for purpose of public order that the accused be denied bail. On submissions, the grounds were ably expounded by the learned prosecutor, Ms. Kiumba, Mr. Kipkoech, Mr. Abuya, and Mr. Wanjir. On the first ground on witness interference, they jointly submitted in support of the position while placing every reliance on the affidavit deposed by Elizabeth Auma Ogega. It was their submission that there is a real likelihood of witness interference by the accused persons if admitted to bond. They cited an incident where the deponent was approached by a Mr. Osea, who made attempts to coerce the deponent to drop the case through attempted financial inducement through bribe. It is on that basis that they see real likelihood of witness interference. To buttress this position, they refer this court to the case of Republic versus Danson Mukunya and another 2010 EKLR. Mr. Callisto, the London Defense Counsel, dismissed any possibility of witness interference and stated that any such threat must be real and not mere conjecture and speculation. He categorically stated that no such threat has been stated both in the affidavit and submission. He summed up by stating that the assertion by the prosecution on this ground are imaginary and mere unsubstantiated allegation. On the second ground, the counsel for the family of the victim stated that the investigation in this case are still ongoing. Mr. Abuya stated that the victim in this case is still missing despite being last seen with the accused persons. He went ahead to state that should the accused persons be released on bond or bail, and considering that the scene is under their control, then there is a real likelihood of interference of investigation. In response, Mr. Callisto dismissed that ground, terming it as far-fetched and so remote. That ground that was submitted was that there is great imbalance on the victim and the perceived aggressors the accused herein. Mr. Kipkoech submitted that it is in the interest of justice that the accused are denied bond at this stage, or maybe the accused request to be released be deferred to such a period that the vulnerable witnesses shall have testified to avert the imminent witness intimidation. On the last ground, which was heavily submitted by Mr. Wanjir, this court was urged to take judicial notice of the fact that since the inception of this case, there has been public unrest and protest, hence the accused would disturb the public order and undermine peace and security. He submitted that pretrial detention of the accused persons is public order and security. Mr. Callisto, on his part, Mr. Callisto, on his part, urged the court to grant bond to the accused persons who he said are fixed aboard and who would not interfere with the prosecution witnesses and willing to abide by any condition that may be imposed by the court. This is my considered view. Having heard the able submissions by the parties herein, the supreme law that governs grant of bond or bail is Article 149(1)(h) of the Constitution, which states as follows: 49(1). An arrested person has the right to H, to be released on bond or bail on reasonable condition, pending a charge or trial, unless there are compelling reasons not to be released. The right of the accused or arrested person to be released on bond, as granted by the Constitution, is not absolute. It has been limited by the Constitution itself in two aspects. First, release on bond or bail will be on conditions, although must be reasonable conditions. Second, to the extent that there are compelling reasons, the accused should not be released on bond. The onus of adducing compelling reasons is on the prosecution. For purpose of this ruling, I shall be concerned with the second limitation. The grounds set out by the prosecution and the counsel's watching brief in 5 falls cited above are what they believe are compelling reasons. The Constitution and the succeeding legislation do not define what constitutes compelling reason. Amendment introduced to the Criminal Procedure Code, Cap 75 of the laws of Kenya in 2014, that's under Section 123A, seek to operationalize Article 49H, 1H, that is attempt attempting to single out what constitutes compelling reasons. It is though not conclusive. The judiciary bail and bond policy guidelines set out consideration to be borne in mind by judicial officers in making determination on bond applications. It is not the law either. The greatest milestone has been made by the decisions of superior courts in trying to define what constitutes compelling reasons as envisaged in the Constitution. By the Constitution. In the instant case, the first consideration would be whether the reasons cited and advanced constitute compelling reasons as envisaged by Article 49(1)(h) of the Constitution. What should be borne in mind is the fact that the charge faced by the accused persons is yet to be proved. Hence, the accused reserve the right to be presumed innocent until contrary is proved. It is my view that the intention of the drafters of the Constitution was to ensure that individuals' right to liberty is not curtailed arbitrarily and places greater duty on the prosecution to clearly demonstrate sufficient reasons to warrant an accused being deprived of that right. I will proceed to address the ground cited distinctly and not necessarily in the order stated above. The prosecution and the counsel watching brief submitted that the charge faced by the accused persons is a serious one, that if convicted would attract a severe sentence and a long imprisonment term. The counsel for the family stated that it is the severity of such sentence coupled with the fact that the prosecution is in possession of overwhelming evidence against the accused persons that may be an incentive to the accused to abscond trial if released on bond. Ordinarily, severity of sentence may be a motivation to the accused person to abscond trial if admitted to bond. This, to me, cannot be a stand-alone ground to deny a person charged bond or bail. This alone cannot override the accused's right to liberty. As I mentioned in the fore, the penal consequence of the offense faced by the accused is imprisonment of up to 7 years. Can it safely be concluded that the accused persons may be motivated by the duration of the above sentence period to abscond? My respectful answer is to the negative. The strength or weight of evidence in the prosecution's possession can only be determined at trial. That ground fails. It was extensively submitted before me that there exists a reasonable apprehension that the accused person are going to interfere with witnesses if released on bond. This is founded on the averment contained in the affidavit sworn by Elizabeth Auma Ogega. I lift the relevant paragraphs as follows. The affirmation that approximately 3 weeks ago, this is what the deponent said, that approximately 3 weeks ago, I was approached by an individual who identified himself as Osea and who claimed he had been sent to talk regarding my son's case. That during the conversation, the said Osea told me he could help me have the matter settled and strongly implied that I should stop agitating for justice. That he then asked me to quote my price so that this matter can go away. that I understood this as an attempt to offer a bribe of financial inducement in exchange for my silence and withdrawal from the pursuit of justice for my missing son. That before leaving, Osea stated that he would return soon to escalate the discussion, which I understood to mean further pressure, offers, or threats would follow. That I was deeply disturbed by this encounter, and I interpreted it as a clear attempt to interference with the ongoing investigation and obstruct the course of justice. End of quote. It is the above encounter with Mr. Osea that the family of the complainant strongly believe that there is imminent danger of witness interference by the accused persons if admitted to bond or bail. The defense submitted that the witness interference must be real, and in this case, no material has been advanced to demonstrate interference. I respectfully hold the view that witness interference in whatever manner that would cause the witness to give evidence in a particular manner or in a skewed manner, either by compromise, coercion, intimidation, fear, or threats, constitutes compelling reasons to warrant denial of bond, as the end would be an impediment to or perversion of the course of justice. In the instant case, if the affirmance were anything to go by, then there exists a real danger of witness interference. It must though be established that such interference is by the accused or sanctioned by the accused persons. The High Court in Republic vs. Lucy Waweru and 3 others, 2013 EKLR, F.N. Mushemi Judge, held as follows, quote, in regard to all the accused person, the likelihood of interfering with witnesses or intimidating them cannot be ruled out. I share the fear of the prosecution in this regard. The court is under the obligation to do all in its power to preserve evidence in a case where there is a danger of interference with witnesses or likelihood of destroying such evidence. End of quote. In the case herein, the actions by Mr. Osea amount to witness interference. Mr. Osea is not one of the persons charged. A nexus, therefore, must be shown that Mr. Osea was acting for or under express direction of the accused persons herein. Respectfully, no nexus has been drawn. This ground similarly fails. It was similarly advanced the ground that the investigation in this matter is still ongoing, hence the accused may interfere with the investigation if released on bond. It was stated that the victim in this case is still missing. It is therefore the victim's family view that should the accused be released on bond, then there is likelihood that they may further frustrate the search and rescue of the victim, Brian Odhiambo. It is incumbent upon the prosecution to ensure that before arraigning an individual in court, it must satisfy itself that the evidence in its possession is sufficient to prove the charge to be preferred. It would be in clear breach of the rights of the accused person if the court were to direct the continued detention of the accused on the basis awaiting the conclusion of the investigation, especially where no timeline has been stated, mitigated by placing strict condition on the accused than the indefinite detention of the accused. I similarly reject that ground. The other ground that was projected is that the release of the accused person on bond may destabilize public order. It is submitted that it has been witnessed public unrest since the occurrence of the offense herein. Hence, it is necessary that the accused person be denied bond or bail for the peaceful equilibrium to be maintained. This, with a lot of respect, cannot qualify to deny a person charged bail or bond. In the end, I give the following directions. 1, that each accused person herein is admitted to bond of 300,000 shillings with one surety of similar amount or an alternative cash bail of 100,000 shillings each. 2, that the accused persons are prohibited from making contact with the prosecution witnesses listed in this case, either in person or through proxies. 3, that during the pendency of this case, the accused persons are prohibited whatsoever from visiting the identified scene of crime. 4, that the Kenya Wildlife Service is directed to make available anything in their possession that the investigator may deem necessary and useful during the pendency of this case. 5, that due to the public interest that the case has elicited, I direct that the case be listed on priority basis and where possible be heard on a day-to-day basis. Those are the orders of this court. Right of appeal, 14 days.
We are very much obliged on behalf of the Law Society, Voco Africa, IMLU, and the families of the victims, particularly the family of Brian Odhiambo, Your Honor. Yes. We are also guided accordingly on a fast-tracked hearing. I don't know how long the IO intends to supply us with the statements and necessary documentary exhibits. Otherwise, we could come back for hearing as soon as next week. It's a very emotive matter, Your Honor, as you noted already.
Yes.
Where we are doing a case and as captured in your prolegomenon, in the introduction of your ruling, the victim has not been found. So even as we come here, it's a very emotive issue, not just to the family, but to all Kenyans and the international community. We do not know where the victim is, so the sooner justice is administered, the better for all of us. But we pray, as you also prayed, that Brian Odhiambo is found. It would even probably be better if the suspects of the abduction could release Brian before we come for the hearing. I mean, we all pray, Your Honor, that this poor fisherman is released. The family needs him. We all need him.
Yoda, I have instructions from, I believe that is Voco Africa, to request for a copy of the ruling. If we can have that as soon as is practicable, although we understand that Your Honor had given 14 days, then we may need to see what to do thereafter on the advice to our clients. If we can have that as soon as is practicable, possibly even tomorrow, even after these proceedings, we can then make a decision on how to progress with the matter. We have absolutely no problem with the expedited proceedings. We also urge that they be expedited as you have directed. That would also ensure that justice is served as quickly as is possible. That would be on behalf of IMLU and Voco Africa.
Yes, Your Honor, on behalf of the DPP, we appreciate the ruling, and we have made a copy of all the statements of our witnesses, a copy of a charge sheet, and all the documentary materials that we intend to use. These are the call data records, the sketch map, and the work tickets and duty rosters, and I've supplied all those to the Defense Council. The other copies will supply to the advocates watching brief as soon as tomorrow. We can take a hearing date.
Your Honor, with information, I confirm receipt of the prosecution documents they intend to rely upon the trial. We can take a hearing that subject to the court's
I note that we seem to have taken pretrial directions.
Yes.
And then we may need to also make an application.
Yes.
I don't know whether the court would ask us to do a formal one, but we wanted the court to visit the site before trial. Before. Or the court may actually give directions on that, but our view is that we'll need the court to visit.
It would make sense if it's done in the course of trial.
Then if that is the case, I would hold the application until that time would feel it's necessary to visit.
Your Honor, I was of the same opinion with Mr. Abuya, because the locus in Kuo, in this case that is the scene of crime, is within the premises of Kenya Wildlife Services. Kenya Wildlife Services is a big shadow in this court. Your Honor has already noted that it is represented in these proceedings by 2 legal officers. I am told Mr. Mbarak is considering joining KWS in future, not now. In the greener pastures there. But the point, Your Honor, is that it's a big shadow before this court, and considering the orders that you issued for preservation of the locus in Kuo, you will give directions at the earliest on when it should be visited to avoid any interference, because this is an open space. Yes.
Is there any reasonable fear of interference? Because my fear, Mr. B, I didn't understand. My fear would be, if I have not had anyone, what has been seen is just a space. It may not give me that clear picture.
Anyway, Your Honor, since we have a fast-tracked hearing, we will make this application as we get deeper into the proceedings, but we can hold the application for now. Is the court available next week, Your Honor?
Yes, Your Honor, 19th.
We are available, Your Honor.
19th, 20th?
We are still available.
No.
20th will not be convenient on my part.
Bro, 21st. That week is crazy. You see? You need to go to the hospital. Because one is actually open. See this.
Which other dates are available to the court apart from the 19th?
Even when I'm not available, you can proceed.
The other will take us to 26, 27.
You can try 26, 27.
Oh God. 26, 27,
26.
26, 27. You can tell that.
26 is available.
Yeah, it's available.
26th is available
It's available
to us.
We can do 19th and 26th.
Your Honor, we propose 19 and 26.
We have Mondays and Tuesdays, Monday, following Monday.
Yes, it's a Monday. It's a Monday and a Monday.
So we start on 19th,
Then we come back on 26.
then we take the 26th.
If that is okay with the court?
Your Honor, I have a hearing before a three-judge bench on the 27th, 28th, 26th, 27th, 28th and 29th of May at Milimani. It won't be convenient. What I would propose is if we can get an early date in the month of June, I'll be grateful.
It starts with the 19th. We start with the 19th.
So we can start on the 19th, Your Honor, and I think this is an appropriate case where, if you are persuaded, Your Honor, we would wish to make opening statements
Yes.
before the case proceeds.
Is it possible to take then the 20th? Kindly.
It is the reason we didn't accept 19th in the first place.
19th.
20th. Mr.
Granted the 20th and
Sunday,
the 21st.
go with June.
It's available to us.
We can come on the 2nd of June. If,
That is perfectly convenient with me.
we are ready, Mr. Abuya and Jill and us, we are ready to vote, but we can accommodate the defense, come on the 2nd of June for the opening statement and proceeding with the prosecution's case.
I think 2nd of June will be a holy day.
Which way did you?
Let's just
Madaraka.
on 19th.
19th.
Let's do 19th. It's clear for me.
Mine it's not.
Yes, very well.
You know, we could even possibly have a time allocation so that we do not have to, for this purpose.
There is every possibility that we may be taking the other matters. Can we have the 19th from 10:30?
That is
10:30 is convenient to us, you know.
So that I have time to release the others.
We just come to proceed.
And come well fed, we shall be proceedings at 5 p.m.
We are guided appropriately. I think this warning should sound more on the side of Mr. Callisto.
Very well.
That would be the allocation for the opening statements.
I'll be uploading the copy of the ruling right away.
Time allocation.
So we start the opening statement at 10:30.
At 10:30, yes.
Very well. And then thereafter proceed with the hearing.
With your permission,
Yes.
my name is Baraka.
Yes.
Even though my senior pointed out that I'm representing the KWS, but I've not yet received instructions formally to represent the sixth respondent, the sixth accused person, Abdurrahman Ali Sudi. So maybe in the next session, I will have to appear formally. Thank you, sir.
Okay, very well. This is kind of direction. There's a copy of the ruling and they upload there. As soon as I get my fingers, that should be the next 10 minutes. The matter shall be had, the opening statements, on the 19th of May 2025 at 10:30 a.m.
March of time.